right, thanks, Rob. Thanks for having me here. Can everyone hear me? I'm not mic'd up, so I'm just going to try and project. And if I get a little weak, just raise your hands and I'll speak up again. So I'm glad you guys could spend your Saturday afternoon with me. We're going to talk about financing options. And it's going to be a lot more exciting than whatever you'd be doing outside today. Gary gave a great presentation earlier, and I want to echo what he says. I think everything that he says is true. Some things to keep in the back of your mind, especially if this is the first time you're going through it, your first startup, is that, what you're learning is a skill. You get better and better, and it takes education and hard work and perseverance. And I think that's kind of a real truth. So with that in mind, here's what we'll be talking about. I'm going to share with you a little bit about my background, and then I want to learn a little bit about you so I can kind of tailor what I'm talking about to you and to your startups. We're going to just touch on entity formation, and the focus of today's presentation is really the financing options, convertible debt, convertible equity. Yes?
Are you looking for us to make notes, or will you be giving us a slide deck if you email?
If people would like my slide deck, grab my business card, which is up there, and send me an email, and I'll send it back to you. It will send you a good question. We'll go through convertible notes, convertible equity, Series Seed, Series A, those types of things. So my background is I've been practicing now for about 10 years. Before I started my firm 3 years ago, I worked for a large corporate law firm. I actually did mostly litigation at the time, and so I got to see deals go sideways all the time. And I know Gary mentioned before that you'll spend a lot of money with lawyers on term sheets, but my God, if you don't get it right the first time, you'll spend even more in litigation. So look at it that way, and it's all about reframing the issue. I love working with entrepreneurs and startups. We work generally as their outside general counsel, so we deal with these types of issues all the time. And outside, I love skydiving. So if I weren't here today, I'd probably be doing that. I have like 1,000 skydives. So if anyone's interested in that, you can talk to me about it after the program. All right. So let's learn a little bit about you. Who here is in a startup? Raise your hand. Okay, who here is considering starting a startup? Okay, good. Who here is a founder? Almost everyone. Anybody else another early stage employee? No, okay. Who here has had funding before? Okay. What, angel funding or seed funding or?
Angel funding.
Angel funding, and there was another hand?
The first angel and
Okay. And let's see. And who here is interested in learning about convertible debt? Sexy topic, I know. Good, most people are. Who here is interested in learning about venture rounds? Bigger money, right? And who here is interested in intellectual property? Okay. So as we move through everything, feel free to raise your hand and ask questions. As Rob mentioned before, we want to make sure that everything ends up on camera. So you'll have to hold your question until he brings you the mic, at which point you can ask your question and I'll do my best to answer it. Sometimes, especially in these kinds of conversations, people bring up questions that really should be saved till the end, so I'll just let you know and we can talk about it afterwards. Not a big deal. All right, so I wouldn't be a good lawyer if I didn't give you the sort of legal warning and caveats that what we're going to be talking about today is general information. It's not legal advice. We'll be talking about what a number of the issues are. Okay, we'll talk about the rules, but there are exceptions to the rules and exceptions to the exceptions, and I think some of that will be abundantly clear as we move through the material. And you need to get competent, specific legal counsel who is specific and competent in the areas that you guys are dealing with. So, just any off-the-cuff attorney won't be able to answer these questions. You'll end up kind of in a real bind. We see those all the time. We fix them all the time. I'll probably share with you some stories as we kind of move through the material. And so anyway, any answers that I give you guys are off the cuff, not legal advice. Any questions before we move on? No. All right. So let's talk about entity formation, which was the first thing on our list. I have this really stunning photo or picture here where we have the company, right? That's what the founders are creating. Okay? The point of the company is so that you can get capital in there, you can get ideas into it, and you can get folks who have the business skills, the technical skills, the accounting skills, the marketing skills that Gary talked about earlier. You want to have all those relationships memorialized with the company, okay? Because otherwise you're basically not forming a company, you're forming a lawsuit, and that's not going to get you very far. So the whole point is to get this company and have it grow in value. To do that, there's the intellectual property, which needs to pass to the company, and we'll talk about that in a moment. And then there are the folks who have relationships with the company, and those also need to be documented with the company. So it's really ultimately the company that controls the product and the idea and the business itself. So there were a couple, let me talk about that. We'll talk about, okay, before we go into that, I want to talk just about what Gary mentioned before, the issue of folks doing business on a handshake. Okay, that is a real disaster. There are two kinds of things actually. Well, one, it's a lot of work for me, which is good. I frequently get clients who have done that, and then we have to patch them up, and so, you know, it's actually kind of expensive to untangle all the pieces, and many times we can't, okay, because there are already folks who are stakeholders in there, they have a right or a say, and they are no longer incentivized to agree with everybody else. And so quite frequently, if you start on LegalZoom, or if you, or not just LegalZoom, but any of the other sort of companies that do that kind of work, or you just start business on a handshake, you're really just setting yourself up for a lawsuit. And what's really the reason behind that is you want to memorialize who gets what and what happens if somebody leaves. Okay? In startups, you know, typically they're founded by 2, 3, 4, 5 people. There's a core founding group. Okay? But statistically, one or more of the founders is going to leave in the first couple of years. And so if they have their ownership or equity vested all immediately, then they walk away with a large chunk of the company. And at that point, it becomes very difficult to get that back. And it's quite possible, actually, that you will scare off potential investors because nobody really wants to invest in a lawsuit. So just talking about the assignment of equity, there really isn't a market for it. Okay, there's not. People come to me all the time and they say, well, I have 3 co-founders. I think I should get 15%. Bob should get 45%, and the other person should get 40%. That's 100. That may be fine. I mean, we generally find that the person who is running the show or bringing sort of the most value to the company should end up with the most equity when you're starting it up. But again, there's not a specific metric that we use, and there's not. We're talking about basically taking an idea and moving it into something real, and so there's no way to really kind of value that and assess what is right. So, and let's talk about, align with that, when you should be actually founding or forming an entity. So who here has already formed an entity? Okay, most people are in the process. Okay. You basically want to form an entity when you start to have more than one person involved, you start generating intellectual property, and there's some reasons for that. 1, because people may leave. 2, you want to make sure, if you go back to this slide, that the intellectual property itself is vesting in the company. And 3, there are actually a bunch of nasty tax complications if you wait until later and then you try to assign the intellectual property for nominal value. You may end up with a giant tax bill as a consequence of that. So, you know, sometimes people will call me, they're a single founder, they're working on their own idea by themselves. I'll just hold for a second. So they're working on the idea by themselves, and they ask me if they should form a company, and I'll say, well, in those circumstances, you can probably wait actually a little bit until you get a little bit further along. Everyone else should basically start a company right away. I'm not going to get into the details, but generally we form a Delaware C Corp. As Gary has alluded to earlier, I mean, there's kind of a set path and a set model. Okay, Gary was talking earlier about, you know, you need to be a $100 million business in order for it to really be investable, you know, in this particular kind of model. And so frequently we find that Delaware corporations are what will work for that. There are some times when some one-offs, and that's fine too, and you work with your counsel to figure out what is really right for your company. Do we have any questions yet? Am I speaking too quickly? Okay.
Hey, I just have a question around the Delaware companies, especially for foreign founders, to do with visas and those kind of things. Is that still the best method? Let's say you talk in your own country alone, trying to do some deals so that the US company is that other company across continents. The Delaware structure is still applicable?
Yeah, so that's a really good question, and the answer is that would take more time to untangle it than we'd have here. But I will tell you, sometimes we work with companies that get founded outside the U.S. and then they want to come here to the U.S. And you know, it to a certain extent becomes a matter that is driven by the tax consequences, whether or not you have the IP vested outside the U.S. versus inside the U.S. But there's also tension then, because frequently U.S. investors won't necessarily want to invest in a company that is foreign. They're familiar with it, like the sort of the Delaware C Corp or the California Corporation. And so, you know, the kind of issue behind that then is you either need to find investors who are comfortable, okay, because there are some folks who are comfortable investing internationally, or, you know, you may have to, you know, eat the nasty tax consequences and move the IP in. But that's not something you want to take lightly, and it's definitely not something you want to do off of a generalization. Does that make sense? And there was another question, or no? So founders are going to end up getting founders stock, right? And that's just basically, I'm not quite there yet. They're going to end up with founder stock, and that is basically common stock. Common stock gives you the right to vote and to get dividends. Okay, it's sort of the backbone. And those are going to vest over time. We're going to get vesting agreements in place. And one, I want to apologize. I do have this on my slides, but I wasn't able to hook up this slide deck in there. So I'm reading off of a couple slides that I will send you guys later if you guys request them. And that's what we're going off of right here. So for vesting, there'll be vesting. It'll be generally over a 4-year period. Does anyone know what vesting is? OK. So vesting is basically, it's a little bit of a misnomer in the sense that you feel like, well, you're getting like a piece of it over time. But really, technically, what you get is all the stock goes to you with strings attached, so that as time passes, you'll cut some strings off of it, and you'll be able to walk away with the stock that doesn't have strings on it if you leave the company. Does that make sense? OK. And why is it important? It is important because statistically, someone's going to leave, and you don't want them to walk away with a huge portion of your company. It's important also to have that stock. Well, 2 things. One, to issue the stock right away so that you don't have nasty tax consequences, as well as the fact that you want to start the capital gains period. Who here is familiar with capital gains tax, long-term capital gains? OK, so basically, if you hold property for a set period of time, I believe it's a year or more, the tax rate on it is lower than if it's just ordinary income. So you basically want to be able to start that clock earlier. You never know when you're going to be able to sell your company. Maybe you'll be able to sell it quickly in a strategic sale. The other thing, too, with vesting is 83B elections. These are big mistakes that we see that you really can't fix, especially if you get far along. And 83B elections are basically a notice to the IRS prepaying your tax on the cheap stock that you've gotten. So that otherwise, ordinarily what happens is that you get taxed on the stock as you get it. That is, as each of the strings get cut, you would be getting taxed on the difference between the fair market value of the stock at that point in time when the string is cut versus what you paid for at the beginning. So there have been some big companies that have gotten bitten by this. But for example, if you buy the stock for a penny a share initially, or a 100th of a penny a share initially, and then you're getting it unvested when it's worth $10 a share, you're going to owe tax on $9.99. So that would suck. So you got to make sure you get your 83B elections in. And then there are frequently also shareholder agreements in place, so that if somebody leaves earlier and wants to sell their stock, you get a right of first refusal. That is, you get to control who has that equity in the company. You don't want it to be sold to some sort of random person who's then going to have voting rights, especially for such a large portion of the company. Is this making sense to people? Am I putting you to sleep? OK. We got a question from Mr. Hong.
Thanks. Regarding the 83B election, is that for the company or for the individual?
It's for the individual. And I mean, it's a pretty simple 2-page form. You write down your social security number, what you get for the stock, you know, and that's basically it. Your wife or spouse will need to also sign it too.
So each person who receives stock should be that.
If it's vesting over time, yes. But consult your tax advisor. All right. So back to the deck. So let's talk a little bit about securities laws, okay? Because securities laws actually influence a lot of what we do and why the sort of model is set up the way that it is, okay? Well, does anyone know what the securities laws are? Okay, so back, well, there's one other question. Oh, I'm sorry, yep.
Going back to the 83B, can you predate this, meaning not done it properly at the beginning? Once you're close to getting your big funding, can you fix the document?
You can fix almost anything, but you can't fix a failure to file an 83B election within the 30-day period. There are some things that can be, I mean, you could talk to, there are some things, but you got to talk to a tax lawyer about it. There might be a way to basically, we've come across it before, not for any of my clients, but some folks who've come to me who have missed the election, and you know, we've worked with tax counsel on them and they've been able to fix it, but it's pretty hard. And that's kind of the exception to the rule that you're hosed. All right, so securities laws at the turn of the 20th century, and you guys have probably heard of the Great Depression and a lot of yes? All right, good. Oh, good. All right, so at the time, right, there were people running around who were selling interest in companies. Some of them were real, some of them were not real. And basically, they were bamboozling the public. All right, and out of that, in 1933, came the Securities Act, and then another Securities Act came out in 1934. Each of those acts have been significantly revised throughout time. But the core of there is really to protect the general public, okay? You know you're not a bad person trying to bamboozle somebody out of stock, but the US government does not, and the general public at large also doesn't know that. So in order to make sure that the public is being protected, there are these securities laws in place. They can be quite onerous. They require detailed information statements to potential investors. Okay, they potentially require filings with the Securities Exchange Commission, as well as filings on the state level and information given on the state level. So all that costs time and money. It's very, very expensive, unless you are able to fit into one of the exemptions or exceptions. And so we'll talk a little bit about that. But one of the things that sort of allows the model to succeed is pursuing the right kind of investors and making sure that you comply with the securities laws. Because if you don't, you're basically buying a lawsuit only maybe with the US government, or maybe even with some of the other investors, and no one else is going to want to invest in that. Does that make sense? Okay. So typically we find with the rounds that we're going to be talking about, Reg D is the exemption. Okay, most typically it's a Rule 506 exemption. Okay, but that means you need to have accredited investors. Does anybody know what an accredited investor is? Okay, so there are like actually 8 subparts, but the most common, especially when you're talking about angels, are individuals who make $200,000 a year over the last 2 years, or $300,000 with their spouse, or their net worth is in excess of $1 million, but you can't count their personal residence. Okay, so that's who you should be targeting, and when I say targeting, that's who you should be working with. Okay. Friends and family, we can get around some issues. They can frequently invest. There are other exceptions for them. But if you're being introduced to just random people who want to put money into your company, they're probably not that great. They're not that great a fit because of these information requirements. And then another issue comes up with who here remembers when Facebook went public, they were forced to go public? Does anybody? Yeah? Okay. So Facebook was forced to go public because they had more than 500 shareholders, okay? And that law has actually changed. The rule is no more than 2,000, so long as not more than 500 are unaccredited. But if you have too many people with unaccredited status with you, you may be forced to go public before you're ready. The issue of that is it is very expensive to go public, and you just may not be ready for it. Questions? Yes?
Does that mean before
Oh, hold on one second. Thank you.
So, how can an international, angel investor to be accredited?
So you need to make sure you fit out. So the question is, how can you make sure that international investors are accredited? So there are two ways to handle that. One is, if you can. Frequently, the easiest way to do that is there's basically an accredited investor questionnaire. Okay, if you haven't been out doing what's called a general solicitation, you can rely on the accredited investor questionnaire sheet. Okay. If you have, then they need to be vetted, and there are some companies out there now who are starting to take the reins on vetting them, which would include probably having them submit whatever their tax forms are or bank account statements or whatnot. And it's a bit of a mess. The other way to potentially raise from foreign investors is via Reg S, which is listed at the bottom. But you have to make sure that that is only that only applies for people who are truly international. So there's not the intent that the securities will flow back into the United States. So there are ways to do it, but you have to be cognizant of it. Did that answer your question, or?
I'm not, let me clarify this scenario. So I'm referring to, say, over here, the States, we start a company, and then we see the fund from foreign investors, which is, invest the money across the, across the border and investing in the States to this company. Is that,
they may qualify for it, okay? But they may not. We can talk about it afterwards if you'd like.
okay.
All right, so we've talked about a bunch of background information, okay? The entity formation, why you want to make sure that you have those founders agreements in place, that you want to assign the intellectual property to the company itself. Now we're actually going to get into the meat of our discussion. And I'm going to draw upon some of the stuff that we talked about before as we move through this, especially as it relates to the securities laws. But I wanted to give you that background information first so that we can easily talk about it as we go through this material. So convertible debt. I think many of you people understand or have heard what convertible debt is. And indeed, Gary mentioned earlier, convertible debt is debt. Who here has a car note? Okay, right? You got to repay that, don't you? Okay? And if you don't, theoretically, they could take your car. All right? Well, convertible debt is kind of based on that premise. It's debt. You owe money. You got to repay it. Right? And when I say you, I really mean the company. Okay? And theoretically, if you don't pay it on time, you don't comply with the terms, they could force you into bankruptcy. Okay? So it's not string-free. But the real motivating factor is not the debt component. I mean, and we'll talk about what the general terms of convertible notes are, but nobody's really doing it for like 6% a year, okay? It's too high a risk. What they're really more interested in is the conversion component, which is that it will convert into equity, that is an ownership stake, typically preferred, at some point in time. And we'll talk about that in a moment. There's also, you guys may hear of safe instruments, convertible equity. Has anyone ever heard of that? Yeah, a little bit. It's basically, it's a newer type, well, it's a revision on basically options, but it's basically a newer type of instrument where you just strip out the debt component from the convertible equity. So many of the deal terms are basically the same. It's just saying we're going to get rid of this equity component, the debt component, which frequently eliminates the ability to force people into bankruptcy. We're going to talk about Series Seed, also known as Series AA, and then we're going to talk about venture rounds. So I don't want to wait any longer. Let's jump in. So convertible debt, that's typically a seed round. It says the company is growing and developing. It's got its strategy they're honing and market research they're doing and maybe coming up with a business plan and a beta. Okay. Series Seed, well, let me jump back. Convertible debt. Gary mentioned before, generally convertible debt's up to $1 million. That's kind of about right. You can do larger. But frequently, once you sort of cross that threshold, you're going to want to, the investors who are investing are going to have more control and more of a stake in the company. And so they'll end up either in Series Seed or, if it's big enough, even a venture round. And that's usually when the company has traction. So convertible note, it converts debt to equity at a negotiated discount to a future qualified equity financing. What the hell does that mean? Well, basically it means that you get to have a discount. So you get to take the money that you put in as debt, and then when there's an equity financing, you get to apply those funds towards the purchase of that type of equity, i.e. Series A. Okay, so if you put in $100,000, okay, you would end up with $125,000 of Series A stock at the Series A round if the company gets there. But there's a lot of risk. May not get there. So there are some advantages to this and why we end up doing it with the very early stage companies. The reason, one real major reason, is nobody really knows how to value the company, or they don't know the exact value. There's just a lot of uncertainty. They don't know how the team is going to function together, how it's going to come to market, whether or not the market's going to like and accept it. How do you value that? As Gary said, at the end of the day, it's what you make up and agree on. Okay, that's true, but that leaves open a lot of risk, and the fact that you can kind of avoid some of that risk by not applying a value to it right at the moment. It's also far less expensive than Series Seed or venture rounds because you spend less money on lawyers. Okay, there's just less documents, and we're going to get into those as we're moving through it. All right, so let's talk terms. Okay, these are the fun, exciting things that we get to think about. Okay, well, it's debt, right? Who here gets indefinitely to pay back their car? No one. Okay, so you get a set period of time that you get to pay back the debt. That's called the maturity date. Unlike your car, though, generally you don't need to make payments over time. Okay, there's a maturity date. That's when it's all due. It's kind of like a balloon mortgage or something to those of you who are familiar with that. You pick an interest rate, okay, and I wonder if I have a slide. Okay, yeah, we'll talk about interest rates in a second. Conversion terms, okay, those are the terms, and we're going to talk about those in a minute, that apply to when you're actually applying that debt, those debt funds, and getting equity back. Those are the terms there. Amendment terms. Okay, amendment terms are exceedingly important. Okay, you're going to have a number of angel investors. Okay, they most likely kind of get along, but they may not always have the exact same opinion. So then there may be times when you need to amend the terms. Okay, in subsequent rounds, when you're doing subsequent raises, okay, maybe you guys cut too sweet a deal in your convertible note, and in order to get Series A financing, you guys got to recut that deal. So you need to have a way to force the change for everybody, or else it might keep you guys from doing business in the future. And then there are some other remaining terms, but they're not common. One of the things that you will not see in a Silicon Valley deal is a personal guarantee. Okay, does anyone know what that is? All right, that means that not only is the company on the hook, but you as the founder are, and so you're putting up your house or your car or whatever it is that you have. That's not the point. But you have to watch out for that, especially if you're dealing with investors who are kind of outside of this ecosystem. So nuts and bolts a little bit. It can be as low as the applied federal rate. Okay, otherwise you have issues with imputed interest. That's basically income. The IRS sees that there's income to the company because free money has value, and so they want to tax you on that value, basically. It can be as high as 10% in California, but you got to check with the usury laws. Okay, does anyone know what usury law is? Okay, because we all have credit cards, and we're used to seeing like 30% interest rate from time to time. Everyone thinks that like you can just go out and lend money for that, but that's actually not true. There are basically caps. The state sets caps on what you can charge, and federal government does too in certain areas. But what you can charge is interest. So you got to make sure you comply with them. Otherwise, it's really more of an issue for the investors. Okay, it's the way for the company to sort of potentially squiggle out of all or portions of the deal. But still, like you don't want to. It's low-hanging fruit. You don't need to be. You don't need to be in conflict with those laws if you don't need to be. You know.
So what is normal rate, like conditions?
I mean, typically between around 6 to 8%. Okay, but 4 sometimes. It just sort of depends. And the other thing too, and I get this sometimes for clients. They think, well, you know, we have to do a convertible round, and then it's automatically a Series A round. Okay, you can actually do multiple rounds of convertible notes. Okay, it just sort of depends. I mean, the goal here is not to just raise money so that you have money from the investors. The goal is to raise money so that you can grow the business. Okay, so you need to be thinking strategically, as you are because you're here, about raising money, and you need to think about how it's applying. So you can actually do multiple convertible rounds, or you know, whether it's debt or equity. And one of the issues, the reason why I'm talking about that is that anyone familiar with the term like precedent? Yeah, once you've done something once, you know, you're sort of expected to do the same thing again in the future. So if you cut super sweet deals to your first investors, okay, that sets the stage. You may not be able to drive as hard a bargain with the next round. Now, maybe you say things have changed. Okay, we now have market traction. Okay, we're a much more attractive investment, and that's why these guys, you know, they took the most risk. You know, they're getting rewarded for it, and you shouldn't get the same deal as if you had gotten in earlier. But anyone familiar with the term psychological anchor? Kind of once you have that thing out there, people kind of gravitate towards it. I'm just going to take a quick sip of water. Let's see. So these types of loans need to be for business purposes. Okay, you know, unless you work out some sort of deal with your investor, okay, they're not going to expect you to be paying down your house note or even paying yourself back, for that matter. You know, they're putting in their money on a going forward basis. They're not putting in their money so that you can cash out. So there are frequently reps and warranties. I mean, there are not many representations and warranties in these notes, but you know, frequently we will represent and warrant that it is for business purposes and it's going to be applied to the company so the company can grow. And then the last part, you need a pre-existing relationship with the borrower. You know, that's to help fit into one of the securities laws exemptions, especially if you're doing like a friends and family round. Okay. You know, maturity, these things vary. Okay, but you know, 12 to 24 months, 6 to 18 months. What you want to be doing is trying to time when you think you're going to be able to raise your next rounds before this money is exhausted. And then you got to build in some cushion because it always takes longer and it always takes more money. You know, one of the things that you have to pay attention to is the California Finance Lender Law. Okay, it's not a very highly enforced law, but it's a law that applies to people who are lending money to other people or to businesses. Okay, and you know, the point there is that's really more for an investor side issue, but there can be, your investors can get themselves into trouble and end up having legal issues with the states. And so like if you're raising money from your aunt or your uncle or your parents, like, you know, you don't want to set them up for trouble.
So what's the issue there?
So there's a law, it's called the California Finance Lender Law. It says that if you're going to be lending money to if you're a person and you're going to lend, this is it in a nutshell, and you're going to be lending money to California residents, you need to register with us, and you need to pay us a registration fee, and you need to make sure that you've met these requirements. If you don't, you know, you're subject to these fines and whatnot. So you don't want to end up getting your family in trouble. Or your other investors. It's not just family, but okay. All right, so conversion terms. I think one thing to keep in mind about any of these financings is that it's all subject to negotiation. Now, each one is going to have more terms that you can negotiate, which means more money and more time. Okay, but you know, frequently we'll get people in our office and they'll say, you know, just give me the stock one, whatever it is. Well, you know, there is a set of what is kind of normal, okay? And then sometimes you can cut deals better than that. Sometimes you can cut deals worse than that. But there's not generally, you know, if you look at the market, there's not a set one. It's not a one size fits all. There's not a ruler. You know, there are different incubators and other entities out there that kind of publish their own, you know, sort of form. And, you know, they'll have suggestions. But some of those you have to be careful of. Some of them are not necessarily company friendly, especially if you go onto the NVCA, the National Venture Capital Association site. They have a whole bunch of forms. They're great to look at, but they're not necessarily company friendly because they're put together by the venture capitalists. So let's get back to the big premise, right? The convertible debt is so that you guys can get money in. The investor's making it not because they want 6% or 8% or whatever over the next, you know, 12 months or 18 months. They're putting it in because they want a piece of equity, okay? And so at some point, that needs to happen, okay? And they're generally going to do it because they want to get it into the Series A round. So we lay out basically, you know, what is the trigger, okay? At what point do you get to apply those proceeds so that you can acquire that particular type of stock? And does everyone know, I guess actually we could take a moment and just talk about common stock versus preferred stock. Do people know what preferred stock is? Okay. It's what your investors ultimately want to have. Why? Because it has more bells and whistles than your common stock. Okay, common stock, you have the right to vote and the right to dividends. You guys aren't going to be making any money, so dividends really aren't worth anything. Okay, preferred stock has obviously a right to vote. Okay, they have the right to get dividends. There are subcategories that they can actually get with regard to that. They get preferences on those dividends. Okay, they may have a liquidation preference so that if they haven't gotten paid those dividends over a period of time, when the company is dissolved, they get to actually, out of the proceeds of that, you know, that is the selling off the assets, you know, they get to get their dividends back first. You know, if dividends are issued, you know, they may get paid first. So, and we're going to talk a little bit about more, but like those are the types of preferences. There are also voting preferences and other rights that they'll have. And so that's why they really want the preferred stock over common stock. Okay, there's a reason why U.S. founders also want them to have preferred stock. Okay, one of the ways that you motivate employees is paying them cash, but unfortunately you're not necessarily going to have a lot of cash to pay them initially. You'll have to pay them in stock or in equity, right? Okay, so let's get back to like the tax consequences here. You want to basically be able to give that equity, you know, to your employees for as little as possible as it costs to you, okay? And the employees don't necessarily want to have to pay a lot of tax on that. So they want to get it, you know, it's the concept of the IRS, if you don't get something for fair market value, you get taxed on the difference between what you paid for it, assuming it's lower, and what you actually got it for, right? So if your common stock were worth $10 a share and you were selling it to your employees for $1 a share, or, you know, this can work out too in options, and we can talk about that later. They get taxed on $9. Okay, so you want to be able to justify having kind of a lower common stock price for as long as you can. And the fact that the preferred stock have bells and whistles on it is one way that you can kind of separate and say that, well, yeah, sure, the preferred stock sold for $10 a share, but our common stock's not worth it. They don't have X, Y, or Z. Does that make sense? They don't have those bells and whistles. That price difference is because of the bells and whistles. And again, as Gary mentioned, you know, when you're doing stock options, you're going to need to have a valuation, and we can talk. That's kind of beyond the scope of this. But the point is, having a justification for keeping the common stock price different than the preferred stock. All right. In terms of discounts, you know, we typically see 20, 25%. You know, I've seen as low as 15, as much as 35. You know, sometimes we've seen them timed over time. So like, you know, the first month they get a 1% haircut. Next month it's 2%, right? All the way up into sort of 18 months or something or longer. The problem kind of with some of these other things is that it sounds very simple in the concept, but when you're actually like drafting the document and tailoring it, it becomes a bit more complicated. And so it just adds price to doing the deal, which kind of undermines kind of the beauty and the simplicity of doing convertible debt. Questions?
I have also heard about something called founder stock. Is it same as the preferred stock or is something else?
So there is Founders Fund Preferred, Founders Preferred, a bunch of other kind of bells and whistles that are attached to Founders stock. And what it is it is a type of preferred stock that is issued immediately at the outset to the founder. Okay, and what it allows them to do basically is sell, it converts basically to like the Series A so that they can sell that stock to the Series A investor and get liquidity easier or faster. Does that make sense? Okay, now that's a great question because it brings up the issue of, well, I want to be able to retain control. I want to put in bells and whistles into the founder's shares. I want to have special exploding voting rights. All of this kind of stuff you guys have. And I get these questions all the time. Like, I love them. The bottom line comes down to how much clout do you have, okay? And when I say that, I mean, what you're going to be doing is you're going to be pitching somebody and they're going to have to invest in you, so they have to believe in you. If they really believe in you, if you were like Mark Zuckerberg working on his next startup, they would say, of course, we will let you have this and this and this and this, and we'll give you all these special voting rights. But if they don't know you, you don't have a demonstrated success, you may not be able to negotiate that, okay? And so one of the issues is it takes more time to kind of build them in, okay? And then the other thing too is frequently they can get stripped away. In order for you to get money, you're going to have to give up those rights. And so then why will you spend the time to put it in to then have to spend the time to take it out? You know, it's really up to you, but that's the sort of bottom line on creating founder stock with special bells and whistles, especially immediately. Price conversion cap. Who's heard of those? Nobody. Oh my gosh. Okay, tabula rasa. Clean slate here. Good. Well, when you guys like go on and Google convertible stock, or excuse me, convertible debt, you're going to probably come across a price cap, okay? And what the price cap does is it basically protects the angel investor from getting completely blown out of the water if your valuation at your Series A round is enormous, okay? It's basically an extra sweetener, an extra discount. And sometimes people say, does that make sense to people? So instead of getting a 20% discount, you know, the mechanics might work out that they would end up getting a 50% discount. They'd be able to pick up more stock than they would otherwise be able to pick up. And you can run through the math, which I'm not going to do here. Some people say, well, that's a backdoor valuation, okay, because you're going to say, well, it's a 20% discount unless, but there's a conversion cap of 5 million, so that if the valuation at the Series A round is really more than 5 million, I still get to act as if it is 5 million. And it's kind of true, okay, so sure, that's kind of like a backdoor valuation. You're betting that the company is not going to be worth more than 5 million, on your next round of financing. But it's not a true valuation in the sense that you're getting locked in on like your which you could sell common stock to, or stock options for your employees and a bunch of other things too. So that's something to keep in mind. We find that they're very, very common. Okay, and again, it's a term subject to negotiation. You could see 4 million, 6 million, 7 million has been pretty popular, and it can go up from there. Sometimes you can do capless. Okay, if they, if they really want to invest in you, you can go capless because that really benefits the company more ultimately in the long run. So there are also optional conversions that we put in there, right? There are other scenarios, right? Unfortunately, it's not guaranteed that you're going to raise a Series A round, and certainly not within the maturity date. Okay, it might take more than the 12 months that you have in there, or the 18 months that you have in there. So the issue is, right? It's debt. And so if there's this debt hanging out there, they can call it. If you haven't paid on time, they can call that debt. Well, what are some of our options? Well, one, okay, you had that provision put in there earlier dealing with being able to get a majority vote by the outstanding debt holders so that you can push back the maturity date so that they won't go after you. Great option. Another is maybe it'll be optional conversion at the maturity date into common stock. Okay, sometimes we do that as well. So basically they end up becoming common stockholders, common shareholders. Yes?
When they extend the terms by voting, extend the maturity date by voting, are there usually some add-on terms, or do they usually stick to the original?
That's a good question. It's all subject to negotiation. Frequently, that's the only term that's changed, but they could ask for more, or they could change. They can make other changes. With regard to that, it's something that not only does the majority. I mean, the majority doesn't get to unilaterally do that. It has to then be in an agreement with the company. So the company has a say, and they have a say. Does that make sense? You know, another great thing is, well, potentially a great thing is. If there's a change of control or sale, maybe you guys get acquired, you know, before the note becomes due, and it never converted into Series A. Well, frequently you'll want to have them convert. You know, so we can build in a couple different provisions in there. One is it converts to common; they get paid out as if they were a common shareholder, which is frequently pretty good. Or sometimes we'll also build in another option where they'll get 1.5 times their money back, or twice whatever they put in. So they'll sometimes get to choose between getting, if they put in $100,000, they get $200K back, or get treated as a common holder. You know, and then they choose whatever is most advantageous to them. Beauty of the structure of convertible debt or convertible equity is it's normally just two documents. The note, purchase agreement, and then the note itself. Okay. The other thing when you're doing any of these financings is that, remember, it's not you, it's a company. Okay, so the company needs to come together and make a decision. Okay, and the company does that by its board of directors coming together either in person or on the phone and in a meeting, or by doing a unanimous written consent. So there's corporate authorization for any of this. Okay, and then there's a note, purchase agreement, and a note. Those are your documentation, basically. Other one, too, obviously, going back and forth is the term sheet. So, okay. So Series Seed is sort of the middle position. It's not sort of. It is the middle position between convertible debt and a traditional venture round. All of that is available online to you at seriesseed.com. And when I say it's in between the two, it's basically like a slimmed down A round. Okay. There's going to be a stock purchase agreement, a limited investor rights agreement, which will, you know, put forth some informational rights and maybe a board of directors seat. A liquidation preference. I talked about those earlier. That is, does anyone know what happens if a company goes under? Lots of times, nothing. But sometimes, especially if it's really early and they haven't, you know, have no traction. But you know, if they have assets. Things can happen. They can go into bankruptcy, or they could just go through an unwinding process where they would basically gather around, tally up what all your assets are, okay? And first you have to pay all your creditors, right? So to the extent you have debt out there, those debts get paid first. You know, maybe along, you know, whether those debts are because of investors or whether those debts were because of service providers. Maybe you guys haven't paid your rent for a while. Not you guys. Maybe the company hasn't paid its rent for a while. So basically, creditors get paid first, and then if there's any money left over, it gets doled out amongst the equity owners. Okay, and this whole process is called liquidation. And you know, common shareholders get paid last. Okay, if you have preferred stock, you have liquidation preferences, you get paid first. So that's one reason why people want to have that. You know, the other thing too is sometimes people consider convertible debt to be kind of like a super liquidation preference because it's a debt. It has a debt component, so it actually would get paid back before a Series A or a Series Seed share would. So getting back to the docs, there's an amended and restated certificate of incorporation. Does anyone know what a certificate of incorporation is? That's the document you file with the state that gives birth to your company. It is basically kind of like the corporate constitution, subject to amendment. Sometimes it takes a lot to amend it, depending upon what it is. Sometimes it doesn't take that much to amend it. And then your bylaws are basically kind of like your statutes. It governs like how the company actually runs. So anyway, when you're issuing, generally, okay, you can actually build into your certificate of incorporation when you're working with your attorney, basically blank check, preferred stock, basically taking the idea that that the board of directors is able to, and the company is able to issue preferred stock at some point in time with the terms not yet known. Okay, when I say that, because all of this is subject to negotiation, you don't know what those terms are going to be until you actually go through the negotiation. So either you didn't take care of it at the front end, which is totally fine, and then you got to amend your certificate of incorporation, most common route, and it'll embody whatever the liquidation preferences and the voting rights and all those things get put into the certificate of incorporation. So, or you can have this sort of blank check one that I talked about a moment ago. Okay, so this is the real Megillah, as they say, and we have about, I think, 20 minutes left. Does anyone have any questions on convertible notes? Yes. Well, you got to wait for the mic. Am I boring people? Is this boring or?
No, it's complex.
It's complex.
And that's my question.
Okay.
So with so much of complexity in the convertible note, and let's say there is a small amount from family, friends, let's say $50,000, does it really make sense, or is there an alternate to that? Because to really document all this and then frame all this in a convertible executable note, a lot of attorney time will go in, and that there goes a lot of expense. So
for a convertible note? Well, you're lucky it's not. But I mean, I wish that it were. I mean, fortunately, we work from templates, right? So, that being said, sometimes 90% of it's there, so the last 10% takes a bunch of time, but it doesn't take nearly as much as if we drafted it from scratch. You would be insane to draft it from scratch because it would take so much time and you would go insane. You would also you can't build a client for that, so you would be you'd be out a lot of money too. So no point in doing that. I mean, that being said, the complexity in a convertible note is not nearly the complexity in sort of these later rounds. And so, I've told you sort of what the basic or standard terms are. They're subject for negotiation. Sort of you stay within that realm, it's not so terrible, especially when you look at the kind of money that you're raising. Okay, the reason why it's not is that there really aren't that many representations and warranties made in convertible notes. I mean, it's just basically the company is set up properly. It's issued the appropriate amount of common stock. It hasn't overissued, and this is what its cap table is. You're not doing a whole bunch of intellectual property representations where, people would want to come through and take a look at the IP agreements and all of that stuff. And so it's not. I feel a little sad that you said that it's so complex, because I guess I didn't want to overwhelm people. It's just these are sort of the standard terms. I mean, really what you're looking at is maturity, the terms of conversion themselves. Okay, this is kind of what's subject to negotiation. The interest rate, what happens in sort of other than conversion scenarios, right? The company gets acquired or there's a change in control, and or what happens if you don't hit the maturity date, as well as what would it take to amend the note. And that's really kind of what gets drafted and what's going to be tweaked. And so it's really kind of those 5-6 things. Does that make sense? But that being said, it is one reason why it behooves you to do what you're doing now and to learn about this stuff and to go and learn what it is now, because I really enjoy educating my clients, and I love working with them, but sometimes if they haven't done any homework beforehand, it could take a lot of time to educate them. So you guys are doing the right stuff and doing this now. And in fact, actually, I'm putting together a video series on this, so I'm going to get that posted the next couple months too.
Do you have examples, particular, like this is a company, this is how it went, like this was the agreement, like just an example of how the calculation goes?
Yeah, so in terms of,
Everything, like.
yeah, so are you saying like, is that what we work from? Or you want me to say what they are right now?
A particular example, right, saying like this was a company, they got like investment of. Yes, example that we can learn from, which is a
Right.
particular one, right? For example, here's a company, they get invested like convertible notes of this amount, this rates, and so on. Then the kind of event Series A happen. They've evaluated to this value. Here's what the investors who own the convertible notes get, and what's left to the year.
Right, okay. Right, so I mean, we have a couple clients that we've stewarded through the process, and it really sort of depends. Sometimes a convertible note, someone will invest, let's say, $15,000, $20,000, okay, where they then will change into a series.
Maybe you can write on the whiteboard.
Okay, so I tell you what, can we talk about this afterwards? Is that okay?
Yeah, sure, maybe it's not interested in anybody else.
Well, do folks want me to talk about this now?
What are you talking about?
So the issue is she'd like to, well, so you know what, I am going to talk with you later, and people can talk to me about it later. I still want to get through the last sort of major portion, and we got 15 minutes left. So we can do a side round. We could do like a Skype call too if we don't have time after that. Yeah, no problem. So Series A will take much more work, much more lawyer time. Okay, the amended and restated certificate of incorporation will encompass many, if not all, of the terms that you're going to work out and that we're going to talk about right here. There's going to be a preferred stock purchase agreement. That's the agreement that's between the company and the purchasers, setting forth a number of things. And actually, if we just jump right in here. The amended and restated certificate is going to have the liquidation preferences. It's going to have anti-dilution protection against issuances of further shares or issuance of additional shares. And basically, that's so that if you have a down round, your investors don't get hosed. They get to pick up some of the advantages of having put in their money earlier at a higher price versus a later investor putting in at a lower price. There may be veto rights for actions like acquisitions, amendments to corporate documents, those types of things. And all that gets put on into the certificate of incorporation, which then gets filed with the Secretary of State. That basically puts the world on notice that there's this group out there that have these rights. So if you were looking to invest in a company, you could very easily pull that up. And it's not just investors who do that. I mean, there are other reasons or other folks who want to look at that stuff too. Okay, so the preferred stock purchase agreement is going to have items like valuation. Okay, that's really kind of the Megillah. That's what you work out. Okay, a company obviously wants to have that valuation, generally speaking. Company wants to have that valuation as high as possible because then they're theoretically giving away less money, or excuse me, less of the ownership interest in the company. But it's not necessarily always great to have an enormous valuation, especially if you can't continue to increase it with that money. So you don't necessarily want to have a down round. That being said, it's not always the worst thing, but not everything can continue to go up indefinitely. So reps and warranties, we talked about them earlier. I mean, this really, depending upon how much diligence the investor wants to do, I mean, they may want to come in and take a look at all your contracts with all your employees. They may want to take a look at all your contracts, regarding the IP. Okay, they may want to take a look at your code, make sure that you're not using code that is part of the public domain. Okay, which wouldn't necessarily be able to have any kind of copyright protection. And it also sets forth the mechanics of the transaction, including when does it close, what office is it at, what's the timeline for doing that. Investor rights agreement. Okay, so the investor rights agreement is a separate agreement. It provides for registration rights. Okay, those are rights that will accrue and pertain if the company goes public. Those are just normally not heavily negotiated. Rights of first refusal. Okay, so frequently, frequently they'll almost always be in there. And the reason for that is that basically by the time you've gotten to like the Series A rounds, you're really talking about, there are a couple things going on. One is the money that's going into the company, but the other is about who's having what amount of control over what period of time, and what are they controlling, and maybe not direct control, but maybe veto rights. How can you block things, you know, that you don't necessarily want to have happen because you're trying to protect your investment? Okay, you put 5, 10, 20, $100 million in there, and you want to protect it. So one of the things that's kind of important is you want to make sure that whatever kind of group or club or investors that you're with other investors who you like, know, trust. And so, you know, if someone's going to sell their shares, the current major investors may want to be able to pick them up to keep other folks out that they don't want to have in there. Okay.
I have a quick question. I have an experienced attorney on my team, and he's very enthusiastic about all this. So my question is, how much do I need to know to communicate to a potential investor? Is this basic information enough, or?
Right. So you should work with your attorney.
Yes,
okay.
but I assume I also need to know what he's talking about, and in communication with an investor, making a deal with that.
Right. Well, so frequently the investor will give you a term sheet, and you'll take that to your attorney, and you will pick it apart. Okay. And you know, and to the extent that particular terms end up in there, your attorney will let you know, like, this is the term, this is what it means, this is what would happen under this situation, this situation, this situation, and these are the alternatives. Do you think you can push for the alternative here?
Okay, so the investor will assume that I will talk it over with my attorney.
Counsel.
Yeah, with my counsel, yeah.
Yes.
Okay.
Okay, voting agreements. Okay, so the investors that are putting in that kind of money want to make sure that they have a say at the table, right? When we went back earlier, we talked about how the company is not you, the company is the board, okay? And the company thinks collectively via its board's actions and thoughts. And as a consequence of that, the investors are going to want to have control over the board composition, okay? So they'll want to make sure that, you know, maybe the Series A and B like have a seat, and the Series C have a seat, and then they're going to want to have an independent director, maybe with some industry experience on the board, okay? And then, you know, maybe the CEO will also get a seat, and then the common shareholders are going to have a seat too. So that's going to be in there, along with drag-along rights, okay? So you should, I guess, to go back to your question, you should be familiar with what these are, but I wouldn't expect one of my clients to be negotiating the terms with the VC directly, or at least not without having had an extensive conversation with me, so that, you know, they know exactly what they want. But you should be familiar with this when you talk with your attorney about it. You know, you kind of get the concept. In the back.
I just have a follow-up question. Like, at what time I should first talk to the attorney? Like I'm a new startup, right? So should I talk to the attorney on like day one, or like whenever, right, in the process? And then like how does it, like how many times in the process I need to talk to the attorney, I guess? At like what stages?
Good question. Okay, so as I mentioned earlier, if it's more than you should be talking to your attorney to see whether or not it's time to incorporate. If you've already generated IP or about to generate IP, you should talk to an attorney to see if it's time to incorporate. If you're just sitting, sitting kicking ideas around by yourself, carry on. But as you kind of move past those points, as you start to work with other people, you're going to want to talk to an attorney to see if it's time to incorporate, because you want to secure that IP with the company. You want to get that stock so you can start getting, you know, some of the tax benefits of holding it early. You want to make sure that you've locked down the relationship with your co-founder, so that if he or she leaves early, you got it and you're not spoiling for a fight. And then throughout the process, I think I like to keep a light touch with my clients. So I mean, we'll check in every couple weeks or so, just an email. And then obviously, as some of these issues, as you start to move closer to some of these rounds and stuff, then you start working much more closely with your attorney, especially once you get a term sheet and whatnot. That's when things really start to pick up. Did that answer your question? Okay. Drag-along rights. Well, basically, if it's time to sell the company, sometimes you need to be able to drag along the other people who may not want to sell it. And so that will be in the voting rights agreement. Rights of first refusal and co-sale rights. Okay. So rights of first refusal and co-sale rights, we're talking about locking up key equity, key employee equity. And the reason for that is that founders will have significant shares. And so we don't necessarily want them to sell their holdings. Refusal on proposed transfers. Well, this is kind of a more new and hotter area. You know, you can actually now put in the bylaws and the charter in Delaware that that you need to get approval before you can sell your shares. And I don't know whether or not that's enforceable in California. The reason for that is California takes a very property owner friendly perspective in that if you own something, if they're shares, you should be able to sell it. Now, it doesn't mean you get to sell it to anybody in the world, but you know, if you've complied with the rights of first refusal and a bunch of other things, you should be able to sell your shares. What's a co-sale right?
For first refusal is for whom? For investors or for the founders? So like whom it
Well,
works for?
there should be rights of first refusal for both.
One more.
Yeah.
Okay, and back on the question of the board composition, what's normally it end up for? Like, for example, now I'm as a founder, have a like one, I participate on the board as one, I have like full solid rights to make a decisions. Like how usually it goes with their Series A?
So board seats are very, very valuable because it gives input, direction, and control for the company, and that's something that gets highly negotiated. You know, it depends on the company. I've seen, you know, VC-backed companies with, you know, 3, which is basically the CEO who represents, you know, basically the common, and then, you know, if it's just a Series A round, it'll just be like the, you know, the A. The investors will have a seat there, and then frequently you want to have somebody who's independent. Okay, somebody with some industry experience. You know, up to sort of 5 or so. I mean, after you start to get beyond 5 plus. It can become more complicated. It's harder to get everybody together, but it just sort of depends. It depends how large the company is. And then the other thing too is generally you don't want to have an even number because you can get what's called deadlock, which is that if, say you have 4, right? 2 people want to go one way, another person goes another way, then you're stuck. So getting the right amount of the getting the right odd number is something that's subject to negotiation, and you know it's a bit of a dance. The other thing is that, and this is more of an entity formation issue, but you don't necessarily want to give everybody a board seat and an officer position right when you're starting. Now, it's not necessarily a bad thing, but the issue is that board seats are very important, and so eventually, you know, if you're just going to have a board of 3 or 5, if you have 3 co-founders, they're going to dominate the board, and you're not going to be able to get the investor to be interested in that. So, does that make sense? So, it becomes a little bit of a dynamic issue in terms of, you know, do you kind of say now no, or have them step down later? Who would be able to tolerate that, and just kind of know your team? Yes.
Are the board seats based on the number of shares each one has, or is it just like if you have, let's say, 3, so it's 2 against 1, or like is it based on the number of shares each has?
Yeah, so normally what happens is, I mean, the traditional thing is that, you know, the stockholders get to elect the directors, okay? But in this scenario, things normally get set by agreement, and then folks will vote along those lines in order to make sure that you have, you know, a Series A board rep, and then you know a common shareholder, not common shareholder, but a board member from the common.
No, what I meant was like, let's assume one board member has majority votes, majority shares, and there are 2 boards.
Oh, I see what you're saying. Yeah, no. I mean, each board member gets 1 vote.
Okay.
Is that what you were asking? Yeah, I mean, I guess you could actually have them do some multiple votes, and I've seen some things set up that way, but normally it's one vote per board member. The other thing too is there can also be advisor positions on the board, okay? And so those are folks who get to kind of sit in and listen on the board, but they don't necessarily have a vote. And sometimes that's fine, okay? Sometimes people just want to be able to listen and chime in and to follow what's going on with their investment. They don't necessarily need to have that control that a board member would have. Does that make sense?
How it correlates with the voting rights that you get with the stocks?
So the voting rights with the stock are separate than the voting rights that a board member has. So if you look at it like this, if you look at it like the way that the US government system is set up, okay, each citizen has a vote to elect their senator, and then in the Senate would be like the board here. Each senator has his or her own vote. They don't get to have like 5 votes or something like that. Does that make sense?
One more question. At the time of the sale, since it's community property in California, does your better half have a some kind of a say, or can he or she make problems?
I hope this is not something that is particular for you, but all right. So the investors generally, right, they set up funds so that that's not an issue. An entity doesn't have a spouse, but for individuals, okay, we frequently will have their spouse sign off on whatever voting agreement or whatever share purchase agreement they have, so that the spouse knows that the spouse can't interfere. They may have an equitable interest to whatever the sale of the proceeds, like a 50% sale of the proceeds, but they don't get to come in and vote. Did that answer your question?
You do that initially? Right?
Yeah, initially, yeah.
So once it's done, he or she does not have anything going forward, any vested interest or anything?
Well, not in interest which she would be able to exercise voting or control. She may have an interest in the proceeds, but you need to also, if you got that kind of situation going on, you got to talk to a family law attorney to set up. I mean, you can exclude from the marital assets or whatever, the stock, but you got to make sure you talk to an attorney about it. I think we're almost done. All right, so decisions. We're just wrapping up here. Convertible debt upsides. It's the most common. It's cheaper. It's simpler. There's no valuation of the company. Which is good because it's kind of difficult or nearly impossible. And it helps justify a low, that's a low, not law, fair market value for the stock. Downsides is that it's debt and may be required to be paid back at some point. Make sure you never sign a personal guarantee. And Series A, it's done when the economics basically support it. And then there's me skydiving. I have a beard in there. You can't see the beard.